I'm Chris Norman. I'm a reporter appointed by Scottish ministers to determine the six way-leave cases which relate to overhead transmission in the vicinity of Garvachy Farm and on Cumlodden Estate in Argyll. Apologies for last-minute changes of times and dates and so on. We're very, very busy with our IT equipment in here because we've got a lot of everything now is happening virtually. The days of us all going into village halls and sitting in opposite ends of a hall and discussing public inquiry matters have gone, and we're now on to very much informal and much more efficient, I think, when it's working, means of virtual meetings. But apologies if there's been some confusion of times and dates. I amalgamated the two dates because, as SSC pointed out, each of the applications relate to the same part of a project, although part of them are made on landowners and part on tenants. And that I thought it'd be better just bring them all together there and just see if we can go through it. It's quite a confusing range of issues on the way this appears as appeals. I mean, clearly, when the regulations in the Electricity Act was first produced, it was never envisaged there'd be so many hearings for new way leaves and power stations, etc. And we are getting an awful lot of cases like this through the office at the moment. And a lot of them don't go as far as this even, but here we are now, and we'll just get on. Again, I'd stress the purpose of this morning's meeting is really informal chat about working arrangements and procedural arrangements to determine the six cases. At no part of the morning do I want to spend any time at all arguing the whys and the wherefores and the need and the cases of parties and so on. That's for another day. It's simply a procedural matter, and I'll go on to explain that in due course. I'd add that I will make a minute of this meeting and pass it around all parties with the key point in it for comment before it's formally seen as a record of the meeting, because there's quite a lot in it. There's quite a lot of overlapping guidance and circulars and regulations and so on. And it's very important that we're all reading from the same song sheet on that. So don't worry too much about making copious quantities of notes. I will make the key notes, and as I say, hopefully by the end of this week, I'll produce a draft minute of this meeting. And if anybody has other comments to make on it, we can adjust that. So we've got a settled position on that. But again, I stress the purpose of the meeting is to simply look at the procedural arrangements for dealing with the six way leave cases, which have been submitted by SSE for land at Cumlodden and Garvachy in Argyll, We'll just go through from that. I think everybody else is familiar with way leave procedures when it comes to planning, and know what the requirements on ourselves, and particularly myself, are on here. But we're here, and essentially the statutory provisions are Schedule 4 of the Electricity Act, which allows power companies to make applications for either the retention of overhead lines or for new overhead lines on that. I have to say at this stage, I'm a little bit not as fully aware of the site because I haven't been to the site, and that's something I want to discuss in the course of this meeting. But it's a bit difficult to put all the bits and pieces together and try and get the big picture of that, and I'll come on to that at the minute. So please excuse my ignorance on local geography matters. I've had the advantage of Google Earth and a good ordnance survey map, but that's as far as I've gone at the moment. So essentially, the way that the procedures are going to be handled is under the 1967 Electricity Compulsory Way Leaves Hearings Procedure Rules 1967. I take it everybody's familiar with those, or as familiar as they need to be, or have the idea in it, and augmented in the course of time. The department here uses Annex F to SODD Circular 17/1998, which sets out the procedure for hearings. And I'll make reference to that document. Again, it's showing a wee bit dated, and it certainly doesn't mention the word virtual at all. And obviously things have moved on since then. But the first thing I just need to ascertain is that, are all parties satisfied that I'm dealing with this via hearings rather than a public local inquiry? There's no one feels that there ought to be a formal public local inquiry, which is much more bureaucratic in its procedure, and so on. But certainly the way that the department here is running these matters, we are putting much of an emphasis on hearings because they're much more informal, and I think we moved much further down the line of understanding the position. And one word that is noticeable by its absence in Annex F of a 1998 circular is the word virtual. As I said, in those days, it was unheard of to do this, but as a product of the pandemic and so on, we are using increasingly the whole issue of virtual hearings like this. There's always a little bit of fast heartbeat, about 5 to 10, in case something is not working or the sound's not right or something. But thankfully, everything seems to be here. And I will refer you to Annex F of the 1998 circular, and people will be able to get copies of it. But the word virtual is not there. But I just want to understand from parties that everybody is satisfied that we're doing this by virtual proceedings. There's no one who's got a pressing need to book the village hall in Inverera or something like that to hold this. We can all just do it from the comfort of our own offices if as far as proceed. So can I again, I'll minute that. But again, if people have other views about this and would want to revert to a more formal and non-virtual procedure, when you look at the minutes, there's your time to comment on that. But I take it to settle position of parties now that we can proceed by a virtual hearing, and that certainly moves matters forward a lot if that's the case.
Yeah, that, just to confirm, the applicant's content to proceed by way of virtual hearing.
Excellent, I'm pleased with that. And those representing parties, is that Kate?
Yes.
You're representing Mr. Ms. Rennie, and Katie, you're representing Cumlodden Estate, and you're quite happy with virtual. Right, that's great. That's one formality over on that. Right. Okay. Again, just to go through the sort of paperwork behind that, we've talked about the 67 hearings procedure, which more or less is the skeleton of where we go, and that's amended by Annex F on hearings, and I'll refer to that sometime during the course of the morning as well. And I assume that everybody is familiar with the Scottish Government publication on applications for way leaves, which was updated in 2022. We're all familiar with that document there, which is a very helpful document that brings everything together on that. Good, we're making good progress. Right, with the exception of not being on the site, which is probably one of the biggest absences of information in my own mind, I've gone through the paperwork that's been submitted. We've got 6 files relating to 6 way leave applications. That's 3 in respect of is it Ms. or Miss Rennie at Garvachy, and 3 in respect of Cumlodden Estate. So there's actually 6 applications for 6 way leaves. All 6 relate to 3 particular pieces of work. And please stop me if I'm reading that wrong, because there's a few things I haven't quite got to grips with yet. But that's the case. And what I'm proposing to do, because the 6 applications relate to 3, and I call it loosely the word project on it, is deal with each one in turn. I think it gets far too complicated if I try to conjoin them, although there's a lot of similarities between the cases in terms of need, etc. Each case has got, each project, I think, has got to be done on its own, because otherwise we end up in something of a confusion about what is relevant to what particular case. So what I would propose to do is look at case A, case B, and case C as an individual, and not, if I can, have too much crossover between the two, because there might be justification for one which doesn't apply to another. And at the end of the day, what I have to do in terms of considering these cases and making a report to ministers is look in particular at necessity and expediency. And these are key words in the legislation. And something might be expedient for something, but maybe not necessary for another, etc., etc. And it gets far too complicated if I was to pull 6 cases to one. So does anybody have any difficulties with that, or any comments to make on that?
Well, can I just clarify, is the position that the 3 applications relating to the landowner will be dealt with together, or is it that the separate elements of the overarching project will be dealt with together? So, for example, WAY-32 and 35 both relate to the 33 kV cable. So will those be dealt with for both the landowner and occupier at the same time?
Yes.
Right. Okay.
Yeah. Otherwise, we'll just expand exponentially and end up with 6 hearings, I think. And I think it doesn't make good sense of everybody's time, and it leads to confusion from experience on that. So what I would want to do, we'll call one particular project Project A, and we'll deal with Project A from the point of view of the applicant, from the landowner and the tenant on that, and look at the various aspects of that, and move to case B and deal with it from the point of view of the applicant, the landowner and the tenant, and then case C. And again, I'll put all this in a letter, and certainly seek your views and to ensure that you're comfortable with that process.
Well, that makes sense. Thank you.
Good. I'm glad something makes sense. It's quite an issue to try to untangle everything here and get it clear, because there's a lot of overlap and so on. Anyway, if I could maybe move on. I don't know whether everybody's got copies to hand of the 2022 guidance, but I want to particular, and I put all this in a letter, but I'm looking at particular annex, sort of appendix, bear with me, appendix 2 of that circular, which sets out supporting information for necessary way leave applications. Now, I think it's very important, as things stand at the moment, that all the information that's set out in Appendix 2 is in front of me, and it's in front of other parties. And what I have in the application, so the appeal forms submitted to Energy Consents Unit by the applicant is certainly more than a basic outline of the background to this, but it's certainly put together in the form of reasons for the appeal. And I've looked at those, and I understand, I mean, in a nutshell, the massive increase in renewable energy that's coming or about to come on stream for wind farm developments down, particularly down Kintyre and so on, many of which have been through colleagues in this office before they were reported to ministers anyway. So I'm familiar with some of the big sites down in Kintyre and so on. And obviously, from what I read, is that obviously has to connect with National Grid, and there's a bit of a gridlock of geography to get it to Loch Sloy, and where it ties into the National Grid overall. That's about the limit of my knowledge on that, but I think that's why there's such a big interest in getting transmission lines in this part of Argyll. But if I look at Appendix 2 of the 2022 circular, there's quite specific of the information that's needed. And I think one of the difficulties, possibly the greatest difficulty, other than the sort of big overall need picture, is putting the various bits of the jigsaw together, because I've got plans there which don't show certainly the extent of Cumlodden estate, nor do they show the extent of the tenancy of Garvachy farm. And it's very difficult to put the 3 plans I've got and get an overall picture of that. If I look at Appendix 2, there's talk about an ordnance survey-based plan of scale of around 1 to 500, showing the land to which the application relates. Now that you can interpret that expression in a couple of ways. The land, is that the land of the estate or specifically the footprint of the development? I don't know, but certainly what I would find it helpful is having a plan of Cumlodden estate showing which part of the estate is subject to the three proposals, and secondly having a plan of the tenancy of Garvachy Farm, which can put that in context. And I don't know how much of Cumlodden estate Garvachy Farm takes up, Robert. You might be able to enlighten me on that. But is it a big proportion of it?
It's a high proportion. If I was to guess, it was something like 40% of that order. But don't quote me on that. But that's
well, absolutely. But that's helpful in its own right, because trying to piece together from the appellant's individual drawings the context of the scheme in terms of Garvachy and in terms of Cumlodden, it's somewhat difficult on that. Okay, but again, I put this in writing. But I think if we look at Appendix 2 in the circular, it should be showing the proposed route of the electric line, the limits of deviation which are there, rights of access, and the boundary of the affected landowner and occupier's interests. So I don't have that information as things stand just now. And also item 7 is an ordnance survey-based location plan, which shows the necessary way leave and how it relates to any part of the electric line. Now, again, I'm not clear what the part of the overall enhancement of connections in Argyll these sites play, and there's nothing been formally submitted to me, which it'll be information for parties in that respect. And one of the things I certainly need from the applicant is not just a consolidated site plan, but showing how this all fits together in the jigsaw of the interests in this part of Argyll and where the substation is. I'll come on to the substation in a minute, okay? And what I will need is a supporting statement from the applicant for each case. And then that will then be prepared, and we'll talk about timescales for other parties who will have a period to comment and rebut it if necessary. And when I actually come to make a decision on the proposal, there'll be a supporting statement with rebutments if that is indeed made. So that's how I want to address that. Plus any additional information from SSE about the whole upgrade of power connections in Argyll, timescales and expediency and necessity and so on are really, really important, so that I can understand that for the point of making a recommendation to ministers. And I'd also like to know a bit about where we are in terms of the Section 37 application. Now, as far as I know, that's now been scoped for environmental impact assessment, but it hasn't been submitted. And as far as I know, Argyll and Bute as planning authority have not objected to it. Am I correct in that?
As I understand it, the application was submitted in November and we've had no adverse representations to date.
And that's the application for the whole line, is it?
This is just for this section of line, although.
Right.
Yes, sir, but I can double check the extent of this Section 37.
Yeah. As far as I know, it hasn't come to us, and it would come to us if there was a statutory objection from Nature Scott or Argyll and Bute Council.
I don't believe that there are any statutory objections as of yet.
Are you anticipating any?
Well, I would like to think not, but
right. You can never tell. You can never tell. Yeah.
I don't believe there have been indications, but it's someone else that would deal with that, so I can
Right, okay. So
clarify.
Right, so that might not come to us, which is another layer of interest in this, because I mean it can get very, very complicated when I'm dealing with way leaves for a particular proposal, and another colleague gets allocated the principle of it. And there's ways, that we work in the office in terms of allocating reported resources to projects. So it wouldn't necessarily mean that I would deal with the Section 36 application. A lot would depend on my own workload and the workload of others as well. But just to make you aware the complexities of all this, with any luck, from certainly keeping this procedure smooth, it's submitted, there's no statutory objection, then it goes to energy consents, who would then decide it. And then obviously the statutory requirements for way leave understanding anyway, but they circumvent that and are materially different considerations anyway. So I wanted to know that, and that's helpful. Is there SSE an environmental statement on that? For that section, when the application was made to ECU?
I think that application is non-EIA because it's relatively short in length.
Right. But there'll be a supporting statement, presumably on visual impact and drainage and.
If required, I can check with the environmental team,
but
it's a fairly short section of line.
Okay. And as I say, it's not within my scope or remit at all to make judgment on the deemed planning permission under Section 37 if it doesn't come to us as such. But there may well be important background information in that application which may be relevant to me deciding whether the tests of expediency and necessity are met. When do you anticipate, SSE, when you know that it's not proceeding to call into us? So, are we weeks away or months away on that?
I'm not entirely sure, but again, that's something that I can clarify with our environmental team.
Yeah.
And come back to you on that.
Right. And can I ask at this point, landowner and tenant, have they been involved at all with that, commenting on it and made any adverse comments on it?
Yeah, there has been some walkovers where we've tried to share understanding of what was going to happen, and so they're not on. They're reasonably well informed in the idea of the proposals and some of the impacts. Yes.
Okay, that's fine. And from the point of view of Cumlodden Estate, are you familiar with the Section 37 application?
Oh, yeah. Yes, similar to Robert, we've discussed it on the ground, but we've not made any formal comment towards any sort of environmental statement.
Okay, right, that's helpful. Right, and related to that is the planning application for the proposed Quarry, if I'm pronouncing it right, Quarry substation. That's going to Argyll and Bute. Has that been submitted to them now?
Yes, so that was submitted on the 23rd of November and was validated on the 23rd of December.
Right.
There haven't been any consultee responses or representations to date.
Right. And it wasn't an EIA application in its own right.
No, I don't believe so.
Schedule 2 planning permission.
No, it wasn't scoped as EIA development, so it was accompanied by a voluntary environmental assessment.
Right, that's helpful.
I think we're expecting determination of that. I think it's next month. It's got a date at committee.
Right, and has there been objections to it from other parties other than landowner and tenant, or
not that I'm aware of?
So you, with a fair wind, you're anticipating it would be granted planning permission, and it wouldn't come to us as an appeal against that, because that then gets further complications in terms of determination and allocation of reporters and so on. So that's trying to get on top of all these different layers of this is really quite complicated. But I think I'm getting a fairly clear picture now of the status. Those what are very critical elements in the determination of this case I've got in front of us. Right. So the question arises for me is whether it's important to deal with these 6 cases in the absence of a final understanding of the planning permission or the deemed planning permission for the Section 37 and the substation. But the way that timescales have to be looked at in this procedure, I suspect we're not going to have a significant clash of interests on that. I mean, it may well be that Energy Consents decline the licence, or Argyll and Bute decline planning permission for the substation. It may well be that they don't. But I think that decision is going to fairly neatly dovetail, because the next thing I want to talk about is timescales for this. And I'm conscious that time is moving on, and these cases have been with us since November. I think we wrote to parties representing both the landowner and tenants a couple of times now with dates, asking for information as to whether you wanted to participate in hearings and so on. And I think there were some delays in getting that. Certainly just on the 23rd of December, and apologies for being in the Christmas post, we specifically said we would want to know, just for our own programming of reporter time and admin backup and so on, by the 6th of January. And it wasn't really until the 10th of January that we finally got some indication that parties were wanting to appear at the hearing. We've had to change a couple of dates because of just the complexity of managing this, and we've got this one settled. But I'm conscious that some time has been not as possibly best used for determining these cases over the last 4 to 6 weeks. But I'm really keen, and really the whole purpose of this morning's meeting is to get dates and diaries that we can look at when the hearing would take place, and then we can work back from that. Anyone got any other comments on timescales at the moment? I mean, what if I look through the Annex F on hearings? There's quite again a complicated layer of dates to look at, because of certain trigger points in the run up to that date have to be complied with. And what Annex F talks about is giving a period of 4 weeks, in which case hearing statements are prepared, and then 2 weeks for parties to make comment on that. And then we just seem to be fresh out of Christmas holidays, and if we start looking at 6 weeks ahead, we're almost looming into Easter time. So it's not that easy to set. But I was looking at having the hearing sometime late March or early April. Does that cause any particular problems with anyone? Again, I'm conscious that we start impacting on Easter holidays and so on. But if we're now basically at the end of January, and we allowed essentially all of February the hearing statements to be prepared, and then for the 2 weeks after that to parties make comments on each other's statements, which takes it into sort of middle of March on that. And then any later in the middle of March, we get involved with Easter holidays and so on. Anyone got any particular feelings or comments on that?
For the applicant, the week commencing the 3rd of April would pose some difficulties that I think we're getting into the April break then. So potentially towards the end of March would be suitable. The applicant can move relatively quickly in terms of submission of documents. I think we're relatively well prepared.
Right.
If that's of assistance.
That's very helpful. If I said we would fix the hearing sometime week ending the 24th of March. I don't want to go into the following week because I have other commitments there myself, but Friday the 24th of March. It's before we start getting tied up with Easter holidays and school holidays and so on.
I'd be supportive of that on behalf of the tenant.
Okay, and Katie?
Yep, I don't have any issues with that provisionally. I'll double check, but it sounds fine.
Right. And of course, the $64,000 question is how long do we allocate for? I mean, there's a lot of information with these cases in terms of the overarching larger picture, and I think that may well be central to the argument about expediency and necessity. And when it comes down to the smaller but equally significant parts of the length of the underground cable and the position of masts and so on, there's possibly not so much time there. But I would certainly I would hope we could deal with the hearing in the course of a day, but been in this job long enough now to know that the best intentions always seem to fall foul towards it. And I would like to sort of allocate 2 days for that with a potential run over. How do people feel about that? It may well take a lot less time, obviously, but what I wouldn't want to do is get halfway through a hearing in full swing and then we've got to adjourn for several weeks because of Easter holidays, etc. And I was wondering if we were to start on Tuesday, the 21st of March, first day of spring, and look at 2 days in there with a potential run over for a third.
I think that would be suitable. I would also like to hope that we could deal with the hearing in 1 day, but I agree that
So would I.
Some leeway would be sensible.
But these things do happen. So if we provisionally said 22nd of March for the hearing, and that meant that everybody's hearing statements had to be, always get this wrong, complete by the 7th of March, okay? And parties would have 14 days between the 7th of March and the 21st of March to make comments on that. And those rebuttal statements would then be focused on in discussion at the hearing. Would that cause any monumental problems with parties at all? And now, again, put all this in the letter, but basically what I'm saying is that by the 7th of March, which is still about 5 weeks away, parties' hearing statements would be prepared, and then parties would have the ensuing 14 days comment on each other's submissions, ready for start on the 21st of March.
Yes, that seems suitable. And in terms of the maps that you've requested, would it be helpful to submit them in advance of the 7th of March?
Well, it certainly would, because one of the other aspects I want to discuss is site inspections, because although I got a fairly broad overview of it, it's simply through a Google Earth aerial photograph, and there's nothing like having your boots on and walking out and seeing what's happening. A site inspection is I really like that to happen. So by no later than the end of the first week of March. Just on that, look, my knowledge is based on the ordinance. Is it walkable in a day from a public road through the forest to Garvachy farm, or would I need transport laid on to get there?
There's existing access tracks throughout the farm from a previous project, so it's walkable.
It's walkable, but you wouldn't recommend taking your own car in that, which is
well, you could do. We can organise to get a vehicle for you and get some dates and times and place with the tenant and the landowner to do that.
Let's do that, because I could say I'll go and walk it myself and enjoy walking the hills of Argyll a lot. But you know what will happen? It'll be horizontal rain and thick mist and so on, and it becomes really abortive. But if I could ask the applicant to provide a vehicle and maybe meet at Bury or Minard down there and just have a good look around the site. And I'd like to be accompanied by representatives of the estate and the landowner as well, because any site inspections of this nature have to be, everybody is there. And it's not the point on a site inspection to organise and state cases. It's just to familiarise yourself and make sure I'm seeing what you want me to see and not seeing things that I shouldn't necessarily need to see. So I think logically, if I can maybe look at Wednesday, the 1st of March, and the day after that, provisionally say want to be on standby on one of those days, and then we can take a rain check the week before and see we're not going to be 6 foot of snow and torrential rain or thick mist or something like that. Okay, so if I could ask that a vehicle is available from for 2 days in that week ending the 3rd of March, and then near the time we'll say which date. Is that sensible to parties as well? Robert, Katie?
Those dates don't suit me personally, but my colleague or the estate or Richard, I'm sure we can sort something out. That's fine.
Okay, thank you for that.
I'm sure we can.
Right. So just to recap then, first week of March, week ending Friday the 3rd, we'll have a site inspection with transport provided by Scottish and Southern for that. On the 21st of March, at the end, the hearing would start, and we'd look 21st and 22nd with a potential run over to the 23rd if necessary, which means that parties' appeal statements have to be in by the 7th of March, and the following fortnight there's rebuttals and comments to be provided before the hearing starts, if I said that correctly. I think that works okay, because I don't necessarily need to see the hearing statements before the site visit. The purpose of the site visit is just familiarise myself with the geography of so on, and I don't necessarily need to have copies of hearing statements in front of me when I'm doing that. Again, I put all this in writing, but if everyone's happy with that, we'll proceed on that basis.
Yes, that sounds good.
Glad you think so. Several overlapping layers here, and then you multiply that by 6 because we've got 6 cases. It's logistical problems, but that seems to work fine. So that means that if we look to have finished the hearing week ending the 24th of March, I would hope that we can get something to ministers certainly during April, early May, depending on other workloads and so on. So that's moving slightly further forward on that. And by which time you may or may not have a Section 36 approval, and you may or may not have planning permission for the Carre substation. But it looks as if, as I said about 20 minutes ago, all these dates can dovetail together on that. Okay. Right. What I'll also do as an annex to the letter is set out the range of additional information that I need to see based on what I've got on file. And certainly what's on file is quite skeletal in some respects, certainly from the applicant's file as statements and relating it to the 275 kV upgrade in Argyll, etc., etc. And then there's a record of discussions that have taken place with parties and an email log and so on. It may well be that I'd like to see hard copies of the emails. And I'd also need to see title deeds or copies of title deeds to the land, because one has to bear in mind that a grant of a way leave actually becomes an incumbent on title. It's not just a notion for ministers to approve it. And presumably that is not exhaustively impossible to get, is it? There's nothing confidential there in terms of Garvachy, in terms of Cumlodden, just so there's a title deed, so I can just have a legal opinion about any other burdens and so on which we may come across in granting way leaves and so on. Again, we put all this in writing to you.
I believe the title information is already available, so that shouldn't be an issue to provide.
For both interests, both Cumlodden and Garvachy. Yeah, it's public knowledge anyway, of what it is. But and I'll set out again the details of the plans that I need. Can I assume, in a bit of a daft laddie question, the 275 kV, is that originating in some of the wind farms south of Loch Ilped, and it's linking up to Loch Sloy as part of the national grid upgrade?
I'll refer to Ian or Grace on this one.
Right. In
So there's been a previous upgrade called the LT40, which went from Inverary to Loch Ilped, and then it's continuing as the LT228 project from Loch Ilped to Crossaig substation. So
where's Crossaig? Where's Crossaig?
Crossaig is not south of Tarbert.
Right.
It's basically at the back of Arn.
Right.
Would be an easy way to describe where it is.
Right.
So that's where the current upgrades are happening, and then what's happening on Garvachy Farm at the moment is, because of the new substation, there needs to be some slight realignment of the new line, and that's why we're looking for 3 temporary towers to move the line to then enable towers on the neighbouring property and near the existing substation to get moved.
Right, and that is then taking a lot of the electricity produced by some of the Kintyre wind farms that have recently been granted by ministers through here, and that then links it on to Loch Sloy, and that hits the wider national grid.
It's just part of the Argyll strategy for upgrades, etc.
Right. That's helpful. But if there's some sort of document, or you can refer to me in terms of the submissions from the applicant and others from representing Cumlodden and Garvachy can see that as well, just to see how it all fits together, because it's a little bit difficult when you're not familiar with the detailed ins and outs of it. But that would be very, very helpful. Supporting statement for each case. Anyone got any questions about that? I mean, I think one of the, particularly from Cumlodden and Garvachy's position, one of the things that's not open to me is compensation and discussing financial aspects of that. That's not within the remit of ministers wearing this particular hat to look at matters relating to compensation. The key words of the legislation I have to have regard to is expediency and necessity. And that's why I was spending a wee bit of time just understanding how this fits in with the picture. And obviously, if people are aggrieved by that, then the issue needs to be focused on expediency and necessity rather than compensation and pecuniary and financial interests on that. But certainly, I'd expect each party to provide me with a supporting statement. Robert, I've seen your submission on Garvachy. It came in last week. That certainly is setting out quite clearly detailed issues about animal husbandry, disturbance, importance of so on, and that's you might want to consider just keeping that or adding to it. Certainly with Cumlodden, I don't know what, and I have no interest at all about the tenant relationships between Garvachy and Cumlodden Estate. It's up to yourselves to set out a statement of case why you would, in terms of those applications.
I don't believe that the applicant has had sight of any representations from the landowner or the occupier for this matter. I don't know if that's something that can be shared by Mr. Shearlow.
Well, you're correct there, because neither has the reporter. I mean, what we have been asking for some time is details of a case, so on. And I've now got a submission from Mr. Shearlaw just came in last week. It's up to Mr. Shearlaw whether he wants to add to it or pass that around at this stage amongst parties or not.
Jim, I'm happy to share, but I would make a point of context in that initial discussions with Grace and latterly with Ian and looking to, one, get an understanding of what the project was or was likely to be, and to have then further discussions on how we could get to a voluntary consent position, for no particular reason, have been very slow and disjointed. And I'm not pointing a finger at anybody. And frankly, I held off putting any formal submission in the hope that we could get a strong engagement in that kind of position. I would also make the point at this stage is that my client is not in any way against the investment, the necessary investment in our view in electrical infrastructure. They are supportive of it. They're just looking for a clear understanding of how it's going to impact their business and how we're going to mitigate it.
No, I've seen some of the communications between parties, and I know that engagement is continuing on that front. If you have submitted anything to the reporters unit, if you would be able to share that, that would be helpful. If it flows into the necessary way leave process, we can consider that.
And I'm happy to do that.
Thank you.
I suppose I'd make one point. I would like to speak to Cumlodden before I do that, and so that because I can say, and I don't think I'm getting ahead of myself, Katie, and that we look to get a fairly aligned and collaborative position. Yeah.
Yep. The landlord and the tenant have a collaborative approach to this, and Robert and I have discussed it. And we also submitted a brief statement just on Friday to Stuart, which again we can review, and it's nothing confidential. I'm sure the client would be happy to share, but I'll check that with them first, Gemma, before we do share it with you, and I'll speak to Robert as well.
Okay, thank you.
Sorry, Katie, on that. You said it's submitted to Stuart. Is that Stuart McCluskey, my colleague?
Yes, my colleague Poppy sent it to him on Friday.
Being Monday morning is why.
No, it's fine, and it's nothing that would probably have added to today, but ahead of the 7th, we'll probably review it again anyway, so
right,
probably not of great significance now.
Right.
That's fine.
Given that parties, forgive if I'm speaking out of turn, seem to be have at least started the whole written submissions procedure, I'm quite happy to move forward that date from the 21st of March to the previous week, to try and move, just to get a decision out on this, because I'm conscious that it has been with us since end of October, beginning of November, and it was still, with a fair wind, got a couple of months yet before there's a decision there. Is there any feeling that the 21st of March could be brought forward to the 14th of March? That's basically 3 weeks rather than 4 weeks to prepare statements.
Yes, I don't think that would be a problem for the applicant, but I do think it would be helpful to see some representations from the landowner and the occupiers, if those are available.
What the landowner and occupiers give you out with the context of the hearing arrangements is a matter for you three parties. I obviously just have to stick to the formal guidelines, and if we said we're having a hearing on the 14th of March, that means that 17th of I'm running ahead of myself. That brings forward the completion of the documents and exchange of information by a week. Exactly.
Can I just say, I have got an expert witness job in the Court of Session which is going to be quite sore on my time in the next 4 weeks. If we could just, I think the existing dates are quite a challenge for me as it is.
21st of March for hearing, and that's the end of February for the representations and site inspections. So we'll stick to that, okay? But if parties want to give each other information out with the context of that timescale, that's a matter for parties. And obviously, what I need is the information ready to hit the ground running on the 21st of March with the hearing. Okay, I think I've covered most of what I wanted to talk through. Again, there's a lot of detailed drafting of this and in a letter and comments about what additional information I need, particularly incumbent on the applicant with regard to bigger pictures, an overview, and a workable ordnance survey plan, so I can piece together the various elements on one drawing. I think that would really be helpful for the site inspection as well, which we're looking at the first week of March there, weather permitting, and I think that would be a lot clearer then. So, having said that, has anyone got any verbal questions at the moment? And obviously there may be issues raised when I do a summation of this meeting later on. Any particular questions at the moment?
No, I don't believe so.
Good. Nothing from the applicant, Cumlodden or Garvachy? No.
No,
Right. Well,
No.
right. Well, hopefully look forward to seeing you all on may or may not end of March, and I look forward to being on site beginning of March, weather permitting. We have to have some flexibility in that. And as I say, if anyone has any comments at all on the letter I'm about to write, is to do it via Stuart McCluskey, and we'll clarify that for all parties. Okay, well, can I thank you all for joining me on a grey Monday morning here in Falkirk, and we'll see you all in due course. Thank you.
Okay,
Thank
Thank you.